This is Children in Justice. It's February 2nd, 2015. And this is our first class meeting. We just talked about learning Module 1. And that module has ended, and people were responsible for completing the readings and the assignments and, of course, the discussion forum. And I'm not going to discuss that. But I'm going to talk a little bit about learning Module 2. A little bit about its design. It's designed just like learning Module 1, and a little bit more about the substantive content. So let's take a look at the objectives. You know, when people ask me, how do I study better? What should I do to prepare for the midterm? Should I get involved in a study group? Should I make an outline? Yes, yes, yes. You should make an outline, and if you can, you should get involved in a discussion group or a study group. If you're an online student listening to this, you can create a study group on Facebook or even within Canvas. I can show you how to do that. I can put together a forum, and I do create a forum for the midterm and the final, but I can create a forum for a discussion group if you want. Those are all great things. The number one thing that I suggest is outlining. You know, you take the content, the assignments, the readings, and you outline them. And as a lawyer who had to go to law school for 3 years and spend the majority of those 3 years reading hundreds and hundreds of pages on a daily basis, you learn rather quickly to get a yellow legal pad and outline stuff. It does two things. One is it lets you think in a logical way about the content that you're reading. And when you put it to paper, you are now emphasizing and helping yourself remember what it is that you read by the mere act of putting pen to paper and writing down what you just read. So it reinforces your recollection, your memories of what you read, and it also causes you to think in a logical, sequential way about what you're reading, in an organized way about what you're reading. It really works, very effective. Well, the other thing is, the reason I thought about all this exam stuff is, go back to the objectives too, because if I made a list of the things that I think you need to remember after I spend 2 weeks of my life trying to share this information with you, and I wrote it down, that's probably what I'm going to ask you about on the exam, or the midterm, or whatever's up next. Now, the answers aren't there, but the broad subject matter is there. And sometimes you can glean by looking at, not only in my class, in every class, we're required to give you objectives. And the objectives are a good way to think about what it is that might be on the midterm or the final exam, if a professor offers that. And I suggest that after we get done with this learning module, you'll have a thorough understanding of the American justice system, including the structure of the courts as well as the people who participate in those courts. I also expect that you will understand the basics of the criminal court process, including arrest, bail, the grand jury, plea bargaining, the criminal trial, and sentencing. And lastly, I expect that you'll understand the family court's child protection process, including the primary forms of litigation. And I meant to ask you this earlier. I am assuming that everyone here works for DCP&P? Is there someone who doesn't work for DCP&P? Okay. And my understanding is my online students, you guys also work for DCP&P. So you guys have a significant advantage when it comes to the child protection stuff, and the family court stuff. Nevertheless, I think that when you listen to my lecture on child protection litigation, and when you read some of the articles and statutes that govern what you do every day, I'm sure you'll learn a couple of things you never really thought about before. Because while you do it on a practical basis, on a daily basis, in a real world context every day, it's often helpful to look at the law that governs what you do every day and think about how your practice either is similar to what the law says or deviates from what the law says. And I'm sure there are many examples where you knew that already because, you know, you are child protection workers. Nevertheless, this is Children in Justice, and we're going to look at children in the criminal justice system. We're going to look at children in the child protection system, in the child welfare system, and we're going to look at children who are accused of offenses that might be considered, that would be considered crimes as an adult. We're going to look at children who are defendants in the juvenile justice system. So that's the way I look at children in justice. How are kids treated in the criminal justice system? How are kids treated in the child protection system? and how are kids treated in the juvenile justice system. And, you know, that's a little bit different there. Where the overall goal in child protection, as the name implies, is to protect kids. The criminal justice system is to hold persons responsible for hurting kids and harming kids, and concomitantly, necessarily, to protect kids. But, well, I was about to say something. The juvenile justice system is really designed to protect kids, too, in the end. Because the goal is, as you'll see when we talk about it, when you read the articles, is not to punish children who commit what would be crimes if they were adults, but to act in their best interests and help them to not commit any more offenses. It's really a system of rehabilitation rather than one that's punitive. But it does have a different vibe, right? I mean, kids go to the detention center when they have nowhere to go. They don't go to a foster home, right? Like in the child protection system. So there are punitive aspects to how kids are treated when they commit offenses that might be crimes. So we're looking at kids in 3 different contexts in this course. Again, criminal, child protection, child welfare, juvenile justice system. And now that's where we are in learning module 2. Now, I'm in the required reading section of Learning Module 2. You'll see there are a number of articles there. Court System and Child Protection by Jones, Medwed's Parole Dilemma, Peter Cilia's Probation in the U.S., Brian Smith's The Purpose of Bail, Taylor's The Cultural Defense in Child Protection, the American Bar Association's paper on plea bargaining. There's a document called Sentencing Criteria, which lists what judges are supposed to look at when they decide on someone's sentence in the criminal courts. There's a hyperlink to the New Jersey court system and a number of readings on the New Jersey court system. Excuse me. And number 10 is a copy of the New Jersey Constitution ballot question that was approved back in November that changed how bail is addressed in the New Jersey Constitution. So those are your readings, and then there's a number of mandatory listenings, if you will. Some of them are PowerPoints where you have to look at it at the same time that you listen. You have to look at it on your phone or on your computer. They're on YouTube. But some of them are audio only, and you'll know by clicking on it. You'll hear Professor Freed, who's my colleague here and a former colleague in the Passaic County Prosecutor's Office, talk about the New Jersey court system. You'll hear a lecture I delivered in a past class on plea bargaining that I thought I kind of nailed it, so I copied it and made it a little discreet kind of plea bargaining lecture. That won't have PowerPoints. That'll just have a static picture of the bell tower and the pen. So that you can listen to in the car. But the ones that are PowerPoints, you got to look at them because that's got the bullet points. You'll have Professor Freed on the grand jury petit jury. You'll have a PowerPoint presentation that I did just the other day on bail in New Jersey. And then you have a 10-minute press conference where Governor Christie tells you why he thinks the bail constitutional section needs to be changed in the state of New Jersey. Then you have, and this is an audio-only one, on the bottom. That's where I was in court on a case called State versus Robert Furman, and I argue a bail motion, as well as do some housekeeping there. I also discuss the latest plea bargaining in court, and I then make an argument to deny this defendant bail. And my adversary is a guy named Dan Palazzo, and he's arguing that he wanted him out ROR, I think. In any event, that was held a couple of years ago in Judge Clark's court, and I had a recording of it, and I let you hear an actual bail hearing. And your learning project is about bail, so that's why there's an emphasis on bail here, as well as other aspects of the court systems. And let me just speak to that learning project right now, because that's due February 15th as well. Your final learning project is going to be a little bit more like a paper. This first learning project's going to be a little less weighty or a little less involved. And here it is here, Learning Project 1. You got a midterm worth 25 points. You got a final exam that's worth 25 points, 50 points. So those are 2 exams. Midterm is at the end of Learning Project 4, just before spring break, I think, or after spring break. I don't know. It's in the calendar I gave you. But it covers learning modules 1 through 4, the midterm. Learning modules 5 through 8 is the final exam. They're each worth 25 points. It's 50 points. The discussion boards are worth 5 points each. There's 4 of them. 4 times 5 is 20 points in the aggregate for your discussion boards. So 50 for the exams. 20 gives you 70. Then there's 2 of these learning projects worth 15 points each. 2 of them, so that's 30. 30 for the 2 learning projects, 20 for the 4 discussion forums, gives 50 in your kind of assignment stuff you got to do. Midterm, final, another 50 gives you 100. And that's what you get at the end there. They all add up, and I posted on the syllabus, which is on Canvas, you know, what the grade breakdown is. I think like a 92 to 100's an A, and I don't know, whatever it says. There's an A minus, like from 90 to 92 or something. But that's how you get to 90 on that grade sheet, by the numbers that make up these assignments. So this Learning Project 1 is your first opportunity to pick up a good 15 points. And it's not hard. If you wait till the last minute on Sunday at 9 o'clock to do it, it won't be good. And you won't get all 15 points, unless you're just that kind of super talent. You know, I had a friend in law school who studied for exams, not by reading the content or outlining the course, right? Not by participating in discussion groups or, you know, doing his own independent research. He just ate a lot of shrimp and clams and other seafood because he claimed it was brain food. He was insane. But he got A's. You know, there's a few people in the world that are like that, who just like have some kind of natural ability to do well on exams without studying. They tend to crash and burn in the end, but that's not us, I'm sure. So if you wait till the last minute and eat a lot of seafood, it's not going to work. What you need to do is start a little earlier, right? Start a little earlier, a couple of days before. Your last learning project is going to be more involved. You're going to have to spend about a week's time on that one. An hour here, an hour there, because that's going to require a few pages, you know, which isn't that much either. This thing's going to take really 1 page, a page and a half. And what you're going to do is you're assigned to an assistant prosecutor who's new to the unit. And that's going to factor in more in Learning Project 2, but she's new to the unit. Her name is Torres, and she's new to the unit, but she's savvy and seasoned. She used to work in homicide and domestic violence, but she's never did child maltreatment cases within the criminal justice system. So there's a fact pattern that describes an ongoing case, and you're going to write a letter to the mother of the victim in that case about bail and what it means. Because maybe you've had this in your experience as DCP&P workers. I know that in my many years in the prosecutor's office, I had victims' moms, victims' caregivers, quite concerned about bail and about what's going to happen once the guy gets charged. And I'm sure you've had clients who have had cases that you were assigned to that also were in the criminal justice system that the prosecutor was handling, and they were quite concerned about whether the accused was going to get out and harass them and bother them, or whether they were in danger, or how come he's not still in jail. He was arrested. The cops believed me. They charged him. Why did I see him at the ShopRite? What's that all about? It's outrageous. He did it. In fact, the cops told me he confessed. Well, maybe he did confess. But as you'll see when you listen to my lecture on bail and read all of these assignments, in American jurisprudence, everyone is presumed innocent. Even if you have a prior record, you're still presumed innocent about this case. So, in order for bail to have any meaning, in a context where defendants are presumed innocent, you have to have an ability to get out on bail, right? Otherwise, it would make no sense to have people that the law says, oh, he's innocent, but he's in jail. How can he be in jail? He's got to have an ability to get out of jail. So the focus of bail really is on showing up for court, not whether you did it or not, although that factors in a different way. And the constitutional amendment, which becomes operative January 2017, will change the stakes dramatically, but we're not there yet, as you'll see. So bail is about showing up for court. That's the purpose of bail. And that kind of makes sense because you're presumed innocent. That's the great thing about American, not in France. Got a lot of peculiar laws in France. Including no presumption of innocence. In fact, you might even be presumed guilty in France. I'm not sure, but I'm not going to get into French law. In America, you're presumed innocent. So if you're presumed innocent, there's no reason to keep you in jail. You are not going to be put in jail until you're convicted. Nevertheless, people have to be somewhere after they're arrested. And the issue that's most concerning to the court is whether they will show up for the trial and any other steps in the process before the trial takes place. There are a number of different proceedings that occur where the court wants to make sure that the accused, that the defendant, shows up to court. So I'm sure you've had moms who were like, why is he out? why is he at ShopRite? Why is he at my church? Why isn't he in jail? And you in Learning Project 1 are going to write a letter to mom, okay? And you're going to explain in a professional, objective way, and I'll address more about that in a moment, what bail means and why it is that the father of her daughter, who was charged with sexually abusing the child, might get out on bail. Because what happened was she got a notice that's generated by a computer. The county jail will send a letter, or the prosecutor's office might as well, saying that he has a bail hearing and he may get out. Mom gets that letter. Is like, what is this? Why is he getting out? They told me he said he did it. Well, he said something, and maybe that something was that he did it. But now he's saying what he said was coerced by the cops, and he didn't mean it. That it was a statement taken in violation of his rights, and more importantly, he's presumed innocent. That statement is not automatically admissible. It's very complex, and you're not going to focus on the admissibility of that statement, but what you're going to focus on is educating mom in an objective, professional, yet informal way about what bail means. And you are the intern assigned to the prosecutor. And she says to you essentially, listen, I think mom's coming to court when I argue the bail motion, but if she doesn't show up, I want to be ready to send a letter to her house. So write a nice letter to the mom. So let's take a look at that real quick, this Learning Project 1. The first thing you have are the directions, which I kind of went over now, and you need to read them in detail. I'm sure I left some things out, okay? And then you have the fact pattern. So the fact pattern is important because that gives you the information, for you to do the letter. Because you need to tell mom what the law is on the issue of bail and what things she needs to be mindful of about her case. And I'll show you what I mean in a second. I had to go into student view because fact pattern looks better in here. So there's this whole description of a case. And this fact pattern is going to be used in Learning Project 2, which is later towards the end of the course. And it talks about what happened. The child disclosed to her teacher that her father kisses and touches her down there. There was a CAP presentation, which is child abuse prevention. She made a statement. She went to the nurse's office. DCP&P went. Kelmont Woods detective showed up. Caseworker showed up. And the story of what happened to this little girl, Wendy Ruth, unfolds, and that's the fact pattern that you're going to rely on. In there is information about the accused, where he lives, his relationship with his wife. There's more than a few things for you to make a bail argument to the mom. Not the argument, to explain bail to mom and what may or may not happen in the case. So just to give you an example without giving you the answer, one of the factors the court looks at is whether the defendant has a criminal record. And we're not making the bail high to punish him because he has a criminal record. Every factor that we look at in evaluating bail is directed at whether he's going to show up for court or not. But if you have a person who has a criminal record and you have another person who doesn't have a criminal record, the person who's more likely to not show up for court, because this is risk analysis, it's really a risk assessment. The riskier guy is the guy who's got a criminal record. The person who doesn't have a criminal record is less of a risk. Both of them could not show up for court and go to Algeria or Ireland and hide, run away. Both of them. But who's the more high risk to flee? Well, the guy who has a criminal record is more likely to flee than the guy who doesn't have a criminal record. Now, that's not the only factor you look at. Why do we look at the criminal record? Well, if you come to court, you're essentially saying, I promise I'll show up. Please give me bail. I promise I'll show up for all of my hearings, for all of my motions. I'll show up for the jury trial. I'll show up whenever's necessary. I promise to do that. Right? That's why I want the court to let me out without any bail on my own recognizance. Well, the court's going to look at a lot of things. Your connections to the community, whether you have a job, all these things I'll go over in a moment, and the PowerPoint video explains in great detail, so do the cases I gave you. But I just want to focus on, for example, criminal record. Well, a person who commits a crime is a person who doesn't follow the rules, right? There's somebody who has broken the social contract in the past. And the more criminal convictions you have, the higher risk, I would argue or suggest. And judges look at that to determine whether this person is a person who's going to show up for court and live up to their promises. And the theory is that a person who breaks the law is not a rule follower. They're not someone, look, if you don't give a damn and you pulled off an armed robbery 5 years ago, you don't care that that's against the law, and you don't care about what happened to your victims and how terrorized they were, and, you know, the trauma they went through and the money that they lost and the time off of work. If you're so sociopathic or uncaring that you committed an armed robbery in the past, I'm not so sure you really care about showing up for court, do you? Now, an armed robbery and a jaywalking are two different things, so the quality of the past crime matters, right? The judge is going to go, well, Del Russo, the guy, you know, was criminal mischief. He was 17 years old. He put his tag on a stop sign. I'm not going to give that too much weight when I decide whether he's likely to flee. But a guy who commits an armed robbery, that might be more impactful. That might result in a higher bail. That person's probably a higher risk. And the reason isn't because he's a bad guy. He's a robber. We want to keep robbers in jail because they could rob again. That's not what it's about. It's about whether he's going to show up or not. Not the robbery. The robbery is relevant to the extent that that is a greater act of mistrust and a greater violation of the social compact. Okay? The robbery and the criminal convictions that someone has show that he's not a rule follower. And in order to show up for court and live up to your promise, you got to be a rule follower. So we look at criminal convictions, among many things. So you'll see in this narrative, the guy might or might not have criminal convictions. And you might want to tell, in fact, that's what the kind of thing you need to do here. When you write your letter to Ruth, I think it's Ruth Baker, Barbara Ruth, I'm sorry. Wendy's mother, the victim's mother is Barbara Ruth. When you write the letter to her, you're going to say something like, and Ms. Ruth, the other thing that judges look at is the criminal record. And your husband, what the heck was his name? Sam Ruth, thank you. And your husband, Sam Ruth, does have a criminal record. but it's one conviction. It was many years ago, so the judge might not put that much weight on it. Nevertheless, that will perhaps cause the judge to raise the bail a little. The other thing that the judge will focus on is this, and the other thing that the judge will focus on is that. That factor will result in perhaps the judge lowering the bail a little bit. So you're going to look at all the facts and circumstances and write a letter to Barbara Ruth explaining to her how the judge is likely to evaluate bail in her case with her husband. And the facts are in there. If the guy's got a criminal record, Sam Ruth, I mentioned it in there. His connection to the community, his relationships, where he lives, all that stuff's in there. You need to explain it to Barbara Ruth. And let me suggest something. When I say you need to be objective, professional, yet informal. When I say informal, you got to write it so a Barbara Ruth can understand it, right? You don't want to say an ipso facto, the Constitution of New Jersey that was duly executed on. And some students in the past have like copied and pasted this thick legal mumbo jumbo and jargon from the actual laws. You have to distill that just a little bit. You're talking to a citizen, an average person. So put it in your excuse me. Put it in your own words. But don't do this. I can appreciate how terrible you feel. Your little daughter was betrayed by a dastardly person. Sam should rue the day that he ever... This is no place to be emotional, no place to put your 2 cents in about how she might be feeling or not feeling. Now, look, a simple pleasantry in the letter, like, I know how you must feel because you got the letter saying that Sam Ruth may get out of jail. I just want to educate you, or I just want to explain to you some of the issues that the judge might look at in deciding whether Sam gets out. Blah, blah, blah. But stay away from, I know you must be feeling lots of pain. It was a terrible thing that happened. He's evil, he's bad, you're sympathetic, I have empathy for you. I know it's hard to do because that's, your bias as a social worker. I mean, you want to help people feel comfortable and you want to, have empathy for them and you want to let them know. But even then you have to be careful about your representations and how emotional you get with your clients, even in child protection. But, a letter about the law is no place for you to get too wordy like that. And I've seen that in the past. So any questions about that? Yeah.
So you don't have to address her concern in the letter, which is you're more concerned about her safety or the child's safety. How do you make the case for that?
Well, if you read this, you'll see what her concerns are, and you're going to address whatever's in this fact pattern. If it says mom's concerned that he's going to hide in a tree, then you're going to say, I understand you're concerned that he might hide in a tree. The court's going to look at, whether he is likely to hide in the tree, and these are the things that the court looks like and things like that. So, yes, you want to deal with her concerns. What I'm talking about is the kind of language and the kind of expressions that we use to communicate with her about her concerns. I understand, you'll see here, she's concerned about a lot. I understand you're concerned about this. Fine. And I feel your pain. Not fine, As I would be too. That's a terrible thing to have a child digitally penetrated by her father. I can only imagine the possible nightmares your daughter may experience. My God, no. Keep it neutral and professional. Even keel, okay? Any other questions? Well, since I'm on bail, I'm going to address bail very quickly because there's a PowerPoint that you need to watch. and I take care of the bail discussion in great detail in the PowerPoint, as well as the constitutional amendment that's passed but not operative yet. Nevertheless, I'll go over it very quickly. Oh, here we go. This statute, it's not a statute, it's the New Jersey Court Rules, 3:26-1. One of the things that you're going to do in preparation for Learning Project 1 is read a case called State versus Johnson, watch my video PowerPoint on bail, and also look at this. The courts took this from the State versus Johnson case, which is a 1972 case where Johnson was charged with a crime in Union County, and he was about to get the death penalty, and then the federal Supreme Court abolished the death penalty, and that changed the dynamic significantly. You'll hear all about the Johnson case in my video tutorial. But the Johnson case went on to list the things that a court needs to look at, as I suggested a moment ago when discussing Learning Project 1. The Johnson court went on to describe the things that a court needs to look at in analyzing whether a guy gets out on bail or not. And as I said, the primary issue before the court is whether the guy's going to show up for court. So the court's going to look at the seriousness of the crime. The more serious the crime, the more likely the guy's going to flee. The less serious the crime, the less likely the guy's going to flee. Doesn't mean he's going to flee. We're just trying to evaluate risk of flight, risk that they're going to flee. So if I'm the district attorney and I'm making an argument, and the guy's charged with a capital crime, one that calls for the death penalty, I'm going to say this is the highest risk. I mean, this crime could result in him getting executed. He's significantly likely to flee. On the other hand, if someone's charged with criminal mischief, tagging a stop sign, writing their name on a stop sign with spray paint, you know, why would somebody leave all their friends and family and things and stuff and, you know, go live in Northern Ireland and run from the law over a small charge, an insignificant charge, one that would result in probation for 3 months? And I'm giving you the dramatic polar opposites: death penalty, criminal mischief. There's a lot of crimes in between. But the point is, in judging whether someone's going to run, the court said, look at the seriousness of the crime that they're charged with. And that makes sense, right? A guy who's going to wind up in jail for a real long time, maybe life without parole, that guy's more likely to run than a guy who's looking at less time. The defendant's criminal record, I just talked about that. Previous record on bail. You'll see that the defendant in the audio clip that I gave you where I'm arguing in Superior Court in State versus Robert Furman, you'll see that when I read a list of charges from his past to Judge Clark, one of them is bail jumping. I kind of bail jumping, Judge. The reason I'm bail jumping, I kind of emphasized it a little bit more because the previous record on bail is real important. Criminal record's important. I just told you why. It's a breach of the compact between us and society, right? It's a guy who doesn't follow the rules. But, you know, it's one thing to have a criminal record for theft. It's another thing if the criminal record is for welfare fraud. Because fraud is a crime of veracity or credibility. It's kind of different from theft. Right? Bail jumping. Well, that crime, we're trying to see if he's a good risk on bail, and he's got a prior conviction for not being a good risk on bail, for bail jumping. Well, that's a powerful factor to raise someone's bail. That makes a person a high risk. I think it's rather self-evident, right? So the previous record on bail, including whether he was ever charged with an offense involving bail, but even if he wasn't charged, if there's a record within the courts of him showing up late, not showing up, warrants, people come to court and they have warrants for them, and you get a warrant for your arrest if you don't show up for court, right? So if you have open warrants, that would be something that would be relevant and more likely to result in a higher bail. The defendant's reputation and mental condition both are important. The defendant, what I call, and others, the roots in the community. How long the guy has lived in the community. Does he have a house? Is it his house? Does he pay for the house? You know, a person who rents is more likely to flee. Nothing wrong with renters, but they don't have enough of an economic stake in where they live as someone who owns a house and paid for it and has a mortgage. A renter flees, they lose their security deposit. A person who owns a home and has a mortgage flees, they could lose their down payment, could be $250,000. So whether you have a stake in the community where you live, whether you have a connection to the community where you live is evaluated. And that includes whether you rent or own, whether you have property in that area, which creates a more strong tie to that area than if you have no property. The relationships you have there. If your father lives there, your grandma lives there, your uncle lives there, your father's father lived there. Everybody I know has always lived in Newark, New Jersey for 5 generations. And essentially, if I was that defendant's lawyer, I'd say, where's he going to go? This is all he knows. He's from Newark. He's lived in Newark. He's never even seen anything other than Newark. He's never been to Pennsylvania or California. Where's he going to go? That matters. Your roots in the community and your connection to the city or town where you live matters. Where your parents live, the property you own there, where you work, if you're working, how you're doing at work. Look, it's one thing if you're working and you get a new job every 3 weeks. The court's not going to be too impressed with that. Because all of these factors, if I can sum them up with 2 words, involve geographic stability. Right? Are you stable in the area where you come from? Right? Because if you are, you'll show up for court. You know, if you lived in Newark your whole life, you bought a house in Newark, your grandpa's from Newark, you own a business in Newark, 3 generations of your family live in Newark, you went to school in Newark, you worked in Newark for 27 years, well, that's a pretty good evidence that you're going to show up to the Essex County Courthouse. But, if you're from Los Angeles, California, and you've been living in New Jersey for the past 16 months, but before that you lived in Hialeah, Florida, and you spent about 1.5 years in Galveston, Texas, and your parents live in Winona, Minnesota, your ex-wife lives in Spokane, Washington. You have an uncle that lives in Bangor, Maine. You got no hooks here. You got no connection to New Jersey. Don't make you a bad guy. I'm not judging anyone here. I'm just saying that it's not that big a deal for you to skadoodle, right? You care. You got no nexus, no connection here. So that's what it's all about. And if you have a stable job and you've worked at that job for a long time and you have geographic stability, you're more likely to stay here. Good job. Now and then somebody comes in and say, look, I'm his pastor, I'm his brother-in-law, I'm the mayor, I'm somebody who has some juice, some standing, some credibility of their own, and they offer that credibility to the court on behalf of this guy. I'm the commandant of the Marine Corps, and I know the defendant, he was in the Marines for 3 years and discharged with honors, and he's a good guy. So what's happening is you're telling the judge, I vouch for him, and the judge probably would be impressed. The commandant of the Marine Corps comes in, that's a guy with some standing, some respect. Now, how much that goes towards the figure that will be the defendant's bail remains to be seen. But that's something that matters, right? So if somebody comes in that's responsible and would vouch for the reliability of the defendant, that's important. And then there's a catch-all, any other factors, those kinds of things. So listen to the PowerPoint or watch it on bail and then do your learning project whenever it's due and you'll be fine. bail comes up in child protection matters and, in the criminal justice system when defendants are charged with child abuse or criminal neglect. And it matters to the kid and the family. You'll also see, and I didn't discuss it now, but it comes up in your readings, there are a number of conditions that the court can attach to bail, including the big one, no victim contact. And when you watch my PowerPoint video, I discussed that at length. There's some new law that governs how no victim contact operates. There's also a section in there where I discuss if the family court judge or the DIFUS judge wants the kid to see the dad and the criminal court judge says the child shall have no contact with the defendant, who wins? Does the family court judge overrule the criminal court judge? Does the criminal court judge overrule the family court judge? Do they get together in the lunchroom and figure it out? There's a process for that now. And that's just one condition. There are a number of conditions. I'm not going to go into them now. They're among your readings and certainly in the video that I discuss about bail. But I want to get into one other thing before I let you go. I'm going to give you an overview of the court system. In your Professor Myers book, you will see his description of the court system in the United States. And it's generally on target. I'll focus a little bit on the New Jersey court system, but it's very similar to what Professor Myers talks about and to the other states in the United States. There are statutes in every state that govern court's jurisdiction. Jurisdiction can be geographical or subject matter. There are other kinds of jurisdiction, but for our purposes, it can be geographical, right, or subject matter. So the Essex County Family Court has jurisdiction over family matters in Essex County, New Jersey. The Somerset County Family Court has jurisdiction over family matters that occur in Sussex County. Okay. The Middlesex County Civil Division has jurisdiction over civil matters in Middlesex County. In each of the descriptions or examples I just gave you, I talked about geographic jurisdiction, but I also necessarily talked about subject matter jurisdiction because the Essex County Family Court operates in Essex County over family court matters. Family court, that's the subject matter jurisdiction. Family courts don't hear car accident cases or medical malpractice. They handle family matters. A judge in the family court does not have jurisdiction over a surgeon who leaves a sponge in someone's body during an operation, medical malpractice case. That would be heard in the civil division. So that's subject matter jurisdiction. So you have courts that have jurisdiction in certain areas, some certain geographic areas, and certain subject matter areas. And to focus on subject matter, you have family courts, which we're going to be concerned with. You have criminal courts. You have, within the family part, matrimonial, juvenile delinquency, child protection, DIFUS, DCP&P, child custody and family violence. So you got the family part is the general subject matter, and within the family part, you have a bunch of different kinds of cases that a family court judge is empowered and has jurisdiction to handle. Child protection, matrimonial, child custody, child support, family violence and domestic violence, juvenile delinquency. Another example are the criminal courts. Another example are patent courts. They're interested in patent law, in the laws surrounding the design of products and inventions, and protecting the intellectual property of the people who design products and inventions, and more than that. But they're interested in patents, in patent law. That would be a subject matter jurisdiction of that particular court. There are admiralty courts. There are military tribunals. Admiralty courts, they decide cases that arise on the high seas. And that's it. They're not involved in family court or the general criminal law or patent law or anything like that. There are courts called courts of chancery or courts of equity. And we're not going to get too much into this, but just to tell you a little bit about those kind of courts. Courts of chancery or courts of equity are courts that people who have a conflict can go to, where that conflict cannot be solved by money damages. There's something that the party wants, that they're suing another party, that can't be solved with money. And you might say, well, anything can be solved. Give me enough money and, I'll go away, right? But, for example, one of the classic examples is, and I'm paraphrasing dramatically, I'd have to look it up, but Dr. Martin Luther King wanted to march, I'll say in Savannah, Georgia, and I'm making it up. There was another city where he wanted a permit to march on Main Street in Savannah, Georgia. And the town fathers denied him a permit to march. He would go to a court of equity or chancery because he didn't want money. He wants to march down Main Street in Savannah, Georgia, right? No amount of money can make up for what he wants to do on, let's say, 4th of July or whatever day that he wanted to march and have a protest or offer a message to the community. So you're not going to solve that with money. He wants to direct that the city of Savannah issue a marching or a parade permit, whatever the document's called. And in those situations, they're seeking what they call specific performance. I want you to direct that the city of Savannah, Georgia, give me a marching permit. I'm not here for money. I want you to tell them, command them to do something. When I was in the Passaic County Courthouse, every now and then, boxing matches would wind up in the equity courts, in the chancery courts. Because the promoters would want a fight to go on or a fight not to go on, or I don't want the fight to go on in New Jersey, it's supposed to go on in New York. I want you to direct that the International Boxing Federation have this fight in New York, not in New Jersey. So money won't solve the issue. They want an order directing that some thing happen, something occur. And you would go to a chancery court. I remember Evander Holyfield was up on the 6th floor, who was a heavyweight champ at the time, and he was up there in chancery court. They wanted somebody to do something. They wanted the courts to order somebody to take some action rather than pay money. It wasn't about money. And that's a kind of court in America. Chancery or equity division, family court, criminal court, patent court, admiralty court. So you have subject matter, and then they operate in a certain jurisdiction. So you have a court that has jurisdiction over a kind of subject matter and in a particular location. Let's take a look at how the courts operate with regard to trials and appellate review. And I'll talk generally, although in New Jersey it's the same way as most states. You have a number of courts that are called trial courts, and Professor Fried talks about this in the New Jersey state court system and in your readings. But you have a number of courts that are called trial courts, and trial courts listen to evidence, and the judges there or juries make determinations about what happened, what the facts are. And then they follow the law and they make a decision. So trial courts decide facts, then follow the law and make a decision. And it doesn't matter whether it's admiralty or family or equity or criminal. The trial courts do the same thing. They decide facts. Going back to Dr. King. Let's say the city of Savannah said, well, he didn't file it on yellow paper in 12-point font by the third Monday before the march. And that's an ordinance, that's a town law in Savannah. Well, whether the judge cares about that, who knows? That could be the law. Maybe he thinks it's too formal anyway. It doesn't really matter, and he's going to overrule the law in some way. Although judges aren't really allowed to do that, but there are ways to get around that. But let's see whether Dr. King did that at all. We're going to have testimony about whether he filed it. We'll bring in the documents that were filed. We'll see whether they were file stamped. A factual issue in the Dr. King Wants to March in Savannah, Georgia on Main Street case is that he filed the paperwork on time. And people will come in and tell the story of the paperwork. They'll bring the paperwork in, they'll look at the stamp, they'll see whether it was signed, they'll look at a calendar, and there might be 10 other issues that matter in that case. The trial court would decide what the facts are. In a criminal case, if somebody's accused of battering a child and committing an act of physical abuse upon a child, there will be testimony about that. And there'll be a trial in the criminal courts. And in the criminal courts, usually a jury will make a decision about what happened and then apply the law. But the first order of business is, was this accidental injury? You have a spiral fracture of the child's thigh bone or the femur. Was it accidental injury or was it intentional or abusive? A trial court is going to figure that out. They're going to listen to people tell the story of what happened and make a determination of what the facts are, then apply the law. Criminal courts, family courts, and juvenile delinquency, some child is accused of making obscene phone calls, put witnesses on, the judge will listen to the evidence, she'll make a decision about whether the boy was making obscene phone calls. The lady who claims to have received them, they will put phone records in evidence, other witnesses will testify, the kid's friend who's a co-defendant will testify against him, he already pled guilty, they will have a presentation of evidence through the testimony of witnesses, physical evidence and documentary evidence, and the family court judge will draw a conclusion as to the facts. I believe there were obscene calls made, although there were only 2 of them. The prosecutor charges 10, but I only find 2. The other ones weren't obscene at all, and then we can't prove that he actually did it. But on these 2 calls, I find that he did make obscene calls, therefore he's guilty of these things, and the law says this. There's a finding, a fact finding. In child protection litigation, you have your initial filing, right? You have your order to show cause. If you have a DOD, you have a removal, you have an emergent removal, you take the child out of harm's way on an emergent basis. The mom doesn't even have time to object because you didn't give her time to object. You took the child because the child was in immediate harm's way. You put the child in a foster placement, you put the child with kin. Now you have an order to show cause. You provide some basic evidence. Eventually the case comes back to court and the parents, they argue that they didn't put the child in harm's way. They didn't commit an act of abuse or neglect. They want a fact finding, which is really a trial. They want a fact finding. Well, the family court will hold a hearing, right? That's what a fact finding is. And they'll listen to witnesses, they'll listen to you, they'll read the doctor's reports, they'll read the DIFAS file, they'll hear from other witnesses and make a finding of fact and a conclusion and apply the law. That's what trial courts do. The next level of court, above the trial courts, are courts we call appellate courts. Appellate courts don't concern themselves with facts. They do not determine facts. Appellate courts' primary purpose is to decide whether the trial court proceedings were fair or whether mistakes were made. That's what appellate courts do. They don't substitute their judgment either. Appellate courts don't say, well, we read the transcript below. We read the transcript of the obscene phone calls, and we believe that 6 of the 10 phone calls were obscene and that the juvenile did commit them. We disagree with the trial court decision that there were only 2 phone calls out of the 10 that were obscene. No, that ship has sailed. The appellate courts are required to give significant deference to the findings of fact that the trial court made. And they are not to substitute their judgment and not to decide the facts again or the way they would decide them. At best, they'll say, we're sending this back. We think you made mistakes in how you decided the facts. Decide the facts again. You know, you heard from an expert from Verizon Communications that should never have been allowed to testify. We're sending the case back. Do it over. And you can't consider what the expert from Verizon Communications said in court. That expert was not allowed to testify. You made a mistake of law. You allowed evidence into the courtroom that shouldn't have been allowed. That changed the outcome. That could have changed the outcome. So we're sending it back for a new trial. So appellate courts do not decide facts. They evaluate the fairness of the trial courts, whether it be an admiralty or family court or criminal law or courts of equity or medical malpractice, whatever it is, civil courts. They don't look at the evidence and substitute their judgment. They accept the findings and then they evaluate whether the court followed the rules or whether they made any mistakes of law. For example, I'll give you an example. In the criminal courts, a person's past crimes are almost always not admissible in front of the jury in a criminal trial. So let's say Danny Pasillo was charged with sexually abusing his 13-year-old stepdaughter. He had intercourse with her. He fondled her on multiple occasions, and he's indicted for sexual assault, endangering the welfare of a child. When he was in Florida, he was investigated for acquaintance rape when he was in college, and he pled guilty to sexually assaulting an unconscious woman, drafting from the Vanderbilt case. He pled guilty and was convicted of sexually assaulting an unconscious woman when he was 19 years old. The New Jersey courts have held consistently, and the rules of evidence in New Jersey say that that conviction in Florida has no relevance to whether he molested his 13-year-old daughter in New Jersey or not. And to the extent that it does shed some light on whether he did this crime or not, it is so incendiary, it's so emotional, it's such a significant crime that the jury would be overwhelmed by it. They would misuse it. Rather than use it for its relevant purpose to suggest that he's sexually aroused by young girls or something, and decide whether he did this crime in light of all the evidence that's produced, they would simply go, oh my God, what he did in Florida is so terrible, we're just going to convict him because he's a bad guy. The evidence is weak, but geez, if he did that one there, he probably did this one here. We don't have a lot of evidence. His daughter was shaky on the stand. In fact, she recanted. But you know what? That Florida thing seals the deal for me. Courts have ruled and continue to rule, and it's the law of the state of New Jersey that prior bad acts and prior crimes are not admissible to show that a guy probably did the crime that he's charged with now. So getting back to the appellate courts, let's say some judge thought that was relevant. Well, the girl that was unconscious was 13, his daughter's 13. It was something that happened near the house of his girlfriend. I think it's relevant. I'm going to let it in. Well, guy gets convicted. The appellate division evaluates the case. They're not going to decide whether he had sex with his 13-year-old stepdaughter or not. The jury has done that. They've concluded that he has. But then they're going to look at whether any errors were made of law. And they're going to say, wait a minute. The judge had a prior act hearing, prior crime hearing, and he let in this conviction from Florida involving an unconscious 13-year-old where the defendant pled guilty. Rule 404B in New Jersey says you can't do that unless there's compelling circumstances. There were no compelling circumstances. The jury should have never heard that. We're reversing the conviction, sending it back to the trial court, have a new trial. Figure out the facts again with a different jury, but you can't provide the jury with any information about his prior sexual assault from the state of Florida. As a matter of law, it was irrelevant, and to the extent that it had any relevance, it was so emotionally powerful that it would have overwhelmed the jury, and it would not have been fair to the defendant. So now, that's what appellate courts do, right? Appellate courts check out whether there was an unfair proceeding or whether the rules were followed properly. They don't decide the facts. And it works both ways. I gave you an example of the appellate court reversing a case because the jury got to hear stuff they shouldn't have heard. Sometimes it happens the other way, where the defendant or even the prosecutor says, or in the family courts, the DAG says, I want this evidence in, and the trial court says no. So the judge can reverse because of stuff the jury heard or the judge heard that they shouldn't have heard. It shouldn't have been part of the fact-finding process. Or the appellate court can reverse because the jury or the judge should have heard something and the trial court judge said no. Say the defense lawyer says, I want to put my pastor on as a character witness. Well, you could put character witnesses on, but I'm not letting your pastor testify. Is he going to come in dressed as a pastor? Well, he's a pastor. He's going to come in clerical garb. What does that mean? Will it be obvious that he's a member of the church or some religious denomination? The defense lawyer says, yes, of course. He's going to come dressed as a pastor, as a priest. Well, he'll have to dress in civil clothing. I don't want the jury to know that he's a pastor. He can come in and say his name is, what is the man's name? His name is Jonathan Pasillo. Well, he can introduce himself as Jonathan Pasillo. He can say, I've known the defendant for a long time. But do not mention that he's a pastor. I think the jury will overrate that, figure he's a man of God, and it will inure to the defendant's benefit too much. I'm not allowing it. Okay, the judge disallowed something. Appellate court gets the case and says, what is that? Where did the judge come up with that reasoning? He should have allowed the jury to know that the person who vouched for the defendant was a pastor. That's an example of the judge saying some evidence is not coming in. Right? The other example was some evidence came in and it prejudiced the defendant. This is the fact that he molested someone and assaulted someone in Florida. In this case, he wanted something in and the court wouldn't let it in. And there's all kinds of examples of evidence getting in that shouldn't have got in, or evidence not coming in, right, that should have come in, that appellate courts will look at. They look at to see whether the proceedings are fair, and they evaluate what the trial court did, the decisions that they made, and the evidence that they allowed or the evidence that they disallowed. And one last thing on that. The next thing they do is decide whether the error was significant or not. Whether it was harmless error or reversible error, okay? Harmless error or reversible error. Harmless error or reversible error. And what we mean by that is, if the stuff that came in had the capacity to impact the decision of the jury, to impact the verdict. And courts don't have a crystal ball, but they make decisions like this all the time, appellate courts. And using my two examples are probably good. In the example where the defendant went to trial and the prosecutor was able to bring in the fact that he sexually assaulted someone in Florida, and the jury heard that, the court would say that was, okay, reversible error. Because it was a significant piece of evidence that, but for that evidence, the jury might have found him not guilty. That's how powerful that evidence was. That's how important that evidence was. The evidence was so significant that the result might have been different. And that's what the appellate court's supposed to do. They look at the mistakes, and they have to determine whether the mistake was so significant that the result might have been different. And I think it's probably most would agree that a jury that wasn't supposed to hear about a rape in Florida probably might have come to a different conclusion if they never heard about that. Then they'd be stuck with the evidence about this crime and not be all emotional about what happened in the state of Florida, which is dastardly and emotional. On the other hand, the fact that the defendant wanted the pastor to come in dressed as a pastor, and let's say he was a Catholic priest, he wanted to wear his collar, and the judge said, I don't want him wearing his collar, I want him in civilian clothing. Appellate court might say, that was wrong. The defendant had the right to have the pastor, the Catholic pastor, come in dressed as a priest with his collar and his ecumenical, in his religious garb, and that was wrong. It was a violation of the defendant's rights to have a character witness in his trial. On the other hand, we find it's harmless error. The result would have been the same. The jury, had they seen him in his religious garb, probably would have come to would have come to the same conclusion, and they would have convicted him. So that's really a lesson for the next case. It doesn't really help this guy out. It was wrong, but you're still guilty, and we're not reversing the case. And one thing the court might say in my example, which would never happen, I'm kind of straining the law a little bit here. The jury was advised that he was a Roman Catholic priest. He described the parish that he was at. He talked about the fact that he was the parish priest there for 25 years. The only thing that was missing was the clerical garb and the collar. I'm not sure if the appellate division would say what impact that would have, if any. While he should have been able to dress in his religious garb, the fact that he wasn't allowed to is harmless error. It did not have the capacity to change the outcome. And that's what appellate courts do. So let's say that was the ruling of the appellate court. The next highest appellate court's the Supreme Court. You can win it. The trial court might say, I'm letting in the Florida conviction. Let's go back to the guy who was convicted for molesting his stepdaughter in New Jersey. And the jury got to hear that he molested an unconscious girl in Florida. Appellate division says, that's wrong. We reverse for a new trial. Send it back to the trial court. Prosecutor says, I think the appellate court got it wrong. This should have come in. I'm going to the Supreme Court. Supreme Court does the same thing. They look at whether there was a mistake of law, whether the rules were followed. They are going to evaluate whether the appellate court did the right thing to the trial court. They also look at constitutional issues as well. But the appellate court can decide those constitutional issues as well. So you got the Supreme Court, which is an appellate court. But the Supreme Court does not hear all appeals. They hear a very small subset of appeals, even in New Jersey. And the United States Supreme Court, which is the federal highest appellate court, hears a very, very minor amount of cases, like 1% or less of all the cases in the United States that arise in all the trial courts. So in New Jersey, you have, let's say, a family court case, you have an appellate review, and then the case could conceivably go to the Supreme Court, but a small percentage is going to wind up in the New Jersey Supreme Court. You can appeal from the New Jersey Supreme Court to the United States Supreme Court. But that's on a constitutional issue. You're not going to appeal on whether the Florida conviction should have come in. The United States Supreme Court's not interested in that. But they're interested in whether the federal Constitution was violated or not. When there are appeals that come from the highest courts of a state, like the New Jersey Supreme Court, they only get involved in cases that present a federal constitutional question. You don't have to worry about that too much. What I want you to understand is that even the United States Supreme Court's an appellate court. They don't hear testimony. But you can get to the United States Supreme Court from the highest court of the state. But generally, the United States Supreme Court is the highest court in the federal system, where you have a very similar hierarchy of courts. Let's say the state of New York sues the state of New Jersey because the New Jersey's bringing their garbage barges and selling them to Staten Island and dumping our trash on Staten Island to a private contractor. And the Environmental Protection Agency of New York sues the state of New Jersey and the private contractor on Staten Island. When two states sue one another, what court do you go to? Federal court. Federal courts hear conflicts between two states. So that would wind up at the federal district court, maybe in New York, or the federal district court in Newark. There's a federal district court in Newark. Not only lawsuits between states wind up there, violations of federal law wind up in the federal district court. I was sued as a prosecutor in the federal district court in Newark because the allegations were that we violated the federal constitutional rights under the United States Constitution of a person that we arrested. So there are certain class of cases that the federal courts have jurisdiction over, and it's more expansive than I just suggested, but suffice it to say, the federal courts have a system of trial courts. The federal district court in Newark, just like the family court in Essex County or the family court in Passaic County, decides facts. You know, and if it had gotten that far, the federal district court, in the case where we were charged with violating the constitutional rights of a woman that we arrested, they would have decided what did we do? You know, where did we arrest her? How did we arrest her? Was she at work? You know, how long did she spend in jail? Facts. The federal district court decides facts, just like the family court in Passaic County decides facts, or the criminal court in Camden County decides facts. Federal district court decides facts. Then there is the Court of Appeals for the Third Circuit. That's the next and what do they look at? What do you think they look at, the Court of Appeals for the Third Circuit? Facts? Are they fact finders, the Court of Appeals in the federal system? What are they interested in?
The fairness of the trial.
Right. Right. And mistakes of law. Mistakes of law. Same dealio. Federal appeal court. They don't decide the facts. The trial courts do in the federal system. If some evidence was admitted that shouldn't have been admitted, or some evidence that should have been admitted was not admitted, the federal court of appeals will listen to that and then either reverse it and remand it for a new trial, send it back to the trial court for a new trial if the mistake had the capacity to affect the verdict. If it was harmless, that's the end of it. And whatever the outcome is there, the litigants can try to ask for what's called certiorari. C-E-R-T-I-O-A-R-I. Certiorari is just Latin for the process of asking the Supreme Court to hear your case. And the Supreme Court is a super appellate court. Super is probably the wrong word. They're just another appellate court, but they hear a very small amount of cases that involve compelling issues that present substantial questions of law. And, you know, they're going to take cases that they think matter. You know, one of the cases that they've been avoiding for a while, looks like they're taking now, I think, although I've been not following it closely, the United States Supreme Court granted certiorari in gay marriage cases. They've kind of been making decisions on the fringes of that, but it looks like they've accepted for review cases that get right to the heart of whether a state can issue a, marriage license and recognize marriage of same-sex partners. So that is the court system in New Jersey and in the federal courts. That's the way things unfold. You'll read something similar in Professor Myers. Any questions about that?
Question.
Yeah.
Can a single court be in charge of civil and at the same time family matters, or different subjects, like dealing with family issues, but also dealing with issues that is not, are not family matters?
Yeah, well, that's a good question. In a sense, the family part, as I said earlier, is involved with a number of different subject matters, but they all kind of have to do with family issues. Like I said, custody and visitation goes to the family court. Domestic violence goes to the family court. Juvenile delinquency goes to the family court, right? Kids, parents, kids who commit offenses, family issues. Divorce, matrimonial, family court. So in that sense, the family court hears a variety of different kinds of cases, but they still have the general subject matter of family law. They can't hear criminal cases. It's beyond their jurisdiction. They can't hear patent cases or equity cases or medical malpractice cases, civil cases, car accident cases. That's for the civil courts. So to that extent, a judge in the civil court can't handle a family matter, and a family judge can't handle a civil matter involving medical malpractice. When they're assigned there, each judge individually is competent as a constitutional judge to hear anything. You can take a judge out of family and reassign him to criminal or civil or patent or equity. So the judge is competent to go there, but when he's there, that particular court can only handle what they have jurisdiction over. Having said that, and maybe this addresses your question a little bit more directly, the appellate courts, they have jurisdiction over everything below. Family matters go there, criminal matters go there, patent matters, equity. The appellate courts, there's not like appellate family courts, appellate criminal courts, appellate medical malpractice courts. Appellate courts, although with certain exceptions, handle all appeals arising from the trial courts in New Jersey and in other states and in the federal system. Did I answer your question? Yeah. Yeah.
But in any given state, how many appellate courts can a state have?
Well, as many as they design and as many as their geography and population need.
For example, New Jersey, how many?
That's a great question. I'm not sure how many there are. Not every county has an appellate court. So you're not like, oh, the Bergen County Appellate Court or the Passaic County Appellate Court. They cover what they call vicinages or regions, and it might cover Bergen, Passaic, and Morris or something like that. And you do your readings. You give us the answer next week, okay? It's in there somewhere. I just don't know the exact answer, you know. But it's in there. It's probably in this one here. This thing here takes you to the website. I'll show you. Welcome to the New Jersey court system. So you'll find the answer in this one here, okay? It's linked in Learning Module 2. But I'll tell you this, there's 21 counties, there's not 21 appellate courts. There's some lesser number, maybe 8 or 10, you'll find out. Anything else? Yeah.
I've heard something about administrative court or something like that. Is that?
Yes, I did not bring them up. That's probably something I should have mentioned. There are other courts of what they call lesser jurisdiction, but they're courts nonetheless, administrative courts. The Division of Child Protection and Permanency, the first appeals go to administrative courts. And what's interesting about them is they pay deference to the Director of Children and Families. She can overrule an administrative court. But then they can appeal to an appellate court of full jurisdiction. But yes, there are administrative courts. If you're a police officer who gets fined for sleeping on the job and you're docked $1,000 pay and suspended for 3 weeks, you can go to an administrative court, which hears, as the name implies, administrative actions, internal actions of governmental subdivisions and the like. And they got judges, and they listen to the evidence and decide whether the guy was sleeping on the job and whether the remedy was fair that was imposed by the police chief. They handle administrative actions. some child protection matters go to the appellate division, and some of the division's decisions go first to the appellate courts. In fact, there's a case, I have to take a look at it. It was one of these slapping cases where there was a substantiation of abuse, and the court ruled that the matter shouldn't have been substantiated. But in the procedural history, it said the administrative judge disagreed and said it wasn't abuse, and Allison Blake overruled the judge, and then it was appealed again. I'd have to look a little bit more into that. I'm not fully conversant with how administrative courts work, but I know that, and I'm going to bring that back to you next week. I should learn a little bit more about that, exactly what cases go to the administrative courts from DIFAS. But they're what's called courts of lesser jurisdiction, and workers' compensation courts. You know, there's a workers' compensation law in New Jersey, and if you get hurt on the job, you know, before you can, and you're covered under workers' compensation, you can't sue your boss. You have to apply, you tell them, you know, oh, I fell on the job, and there's a process for giving you money and disability. There's a bunch of laws. And if you disagree with the amount of money they gave you, or your back hurts more than they say it hurts, and or they want you to go back to work, and you're a teacher and you don't think you should go back to work, you go to workers' compensation court, and a workers' compensation judge will hear your case and make a decision. And there, if you get aggrieved, you don't agree with the workers' compensation judge or the administrative judge, then it goes to the appellate division. These are fact-finding courts of lesser jurisdiction: administrative courts, workers' compensation courts, and a few others. That's a good question, especially when it comes to DIFAS, because you guys, your cases wind up in the administrative courts. And like I said, Allison Blake has some degree of authority over the courts. It's interesting. I have to look more into that. Something else? Okay, weather permitting, I'll see you all here next week, okay? Weather permitting.